Okay, so may I use this opportunity to welcome all of you to this special occasion. I'm excited. I'm excited and happy to be here. Oh, I can see your beautiful faces. Thank you for joining in. I can see one of our Oga, Ambassador Shegun. Please, good morning, sir.
Morning, sir. You're welcome, my son.
We're happy to have you. Thank you. Thank you very much. Thank you for joining us. We're happy and excited to have you. Maybe you can greet the house, sir.
Morning, Your Excellencies. I appreciate you all. Thank you. Thank you. Thank you.
Thank you very much, sir. Thank you. Thank you very much for joining in. Okay, so without waste of time, we'll want to commence the activities for today. And I will start by introduction. So maybe we'll go, I can see the first person on my side. Let's introduce ourselves and where we're coming from before we proceed. Please go ahead. From my right, from my left, I can see Frida. I don't know. Let's go.
Good morning, sir.
Good morning.
My name is Frida Kishili Samani from Kaduna. Hello.
Yes, we are listening to you. Tell us where you are from, your name, what you do.
Okay, my name is Frida Kishili Samani. I'm a Assistant Chief Registrar too with the Customary Court of Appeal, Kaduna State.
You're welcome.
Yes,
we're
sir.
We're happy to have you.
Thank you, sir.
I have this. Let's go ahead. Let's go ahead, please.
Oh.
The next person. Let's do that quickly.
Good morning, everyone. My name is Amina Yahaya, Legal Officer, Sabongari, Kudal Local Government.
Is it in Kano State?
Kaduna State, sir, sorry.
Thank you. You're welcome.
Thank you, sir.
Yes, please. Yes, next.
Hello, good morning, everybody.
Good morning.
Good morning. My name is Dr. Latifat Bello, the chairperson, International Federation of Women Lawyers, Zaria Kaduna branch. I'm happy to be here. It's an honor.
Thank you, Doctor. You're welcome. Thank you. Thank you. Yes. The next person. The next person.
Yes, good morning, everyone.
Good morning.
Good morning,
My name is Emmanuel Samaila, the Judge, Upper Customary Court, Gwentu, Kaduna State Judiciary.
Thank you very much, Your Honor. You're welcome. Here's the next. Can we do this quickly?
Hello, good morning, everyone.
Good morning,
sir.
My name is Anyaji Ifechuku. I am a recent law graduate of the University of Enugu State University of Science and Technology. It's a pleasure to be here. Thank you, Mr. Nanchang.
You're welcome, Mr. Ifeanyi Chukwu. Thank you having you here. Please, here's the next person. Okay, maybe I will just point. I can see Lazarus. I can see your my lord Kadituku Rashid. I can see Janet Audu. Please, let's introduce ourselves quickly so that we can go ahead.
All right. Good morning, everyone. Views of shuttle mediation technique. I'm so happy. Can you guys hear me, please?
Yeah, we can hear you.
Yes, my name is Joseph Omoha. I'm the chairperson of the ADR Society, ABU Zaria. I'm excited to be here. Thank you.
You're welcome.
You're new to our webinars.
Mr. Joseph, you're welcome.
And thank you, sir.
So yes, we can see Lazarus. You can see your honor, sir. My lord.
Good morning. My
You're
name
welcome.
my name is Honorable Kadi Muhammad Tukur Rashid. I'm very happy to be here for this induction, and I welcome each and every one of us to this all-important event. Thank you very much.
You're welcome, my lord. You're welcome. You're welcome. Thank you having you here.
Thank you.
Please, thank you. Thank you. Quickly. You're welcome. Thank you, sir.
Thank you.
Okay. I can see Barnabas John. I can see Janet. Please go ahead.
Good morning, everybody. My name is Janet Audu. Yes. I'm the judge of the customary court Sabo Tasha Kaduna. I work with the Kaduna State Judiciary, obviously.
Your Honor, you're welcome. Thank you.
Thank you.
You're welcome. Thank you. Thank you having you here. Thank you. You're welcome. Yes. Mr. John, I can see you. Joy Josiah. My colleague is here. Gloria Jude, you're welcome. Lazarus. Okay, so Gloria Jude, you can be admitting people into the group. You are a co-host, so you can admit those that are coming in. So I think without waste of time, I believe that everyone has introduced himself or herself. Okay, thank you. You are all welcome to this occasion.
Thank you, sir.
Okay, Mr. Barnabas John, please, can you go ahead?
That's okay. So I don't.
Barnabas John, please introduce yourself. I think everyone has done except you. Oh, I can see Prof. Prof, you are welcome, sir. Thank you very much for coming in this early.
Thank you. God bless you.
We are happy having you, sir.
Thank you so much. Thank you so much. Congratulations, everybody.
Thank you, sir.
Thank you, sir. Thank you.
Yes,
okay, Mr. Barnabas, I don't know if you can hear me. Lazarus, can you hear me?
Yes, hello, can you hear me?
Yes, we can hear you.
Okay, my name is Lazarus Joseph. I work with Niger and Co. Investigation Secretary and legal practitioner.
Okay, thank you, Lazarus. You're welcome. You're welcome. Yes. Please, can we do this quickly, please? If you know you have not introduced yourself, just go ahead and introduce yourself.
My name is Hawaii Ayasayuti from Minanenja State. Legal practitioner, PRO Fida Ninja. Thank you.
You're welcome. You're welcome. Thank you. We're happy having you here. Yes. I think Mr. John is having some issues with his device because we can't hear him. Okay. So thank you very much for joining in. All of you. I want to congratulate you ahead of time. I want to congratulate you all ahead of time for taking the pain, the time to undergo the training.
Thank you, sir.
Thank you, sir.
Yes, thank you.
Thank you, sir.
Okay, so can you confirm if you can hear me?
Yes, sir.
Can you hear me?
Yes,
Loud and
sir.
clear, sir.
Oh, thank you. Thank you very much. Yes, I had to switch between device, and I'm happy that you can all hear me. Thank you very much. Thank you. So let us begin by is there anyone who will volunteer to pray for us before we commence? Quickly.
God is God. And he came, he came, he held my hand, prayed with me. To be honest, I was fully Christian that until after he came. Anyway, he died 2 months after I went home. When I went home, my husband, my husband's gone now, he's not here anymore. He is very domesticated, so he didn't know how to pay bills. And they were
okay. I thought is there anybody? Should I point anyone? Okay, Amina, can you pray for us?
Pray. Brief. Pray.
Pray.
Pray for us.
Is there anyone praying?
Okay.
Hello, Nabil Karim. So I'm praying.
Okay. Go ahead, please.
I pray that Almighty Allah will see us through this program from starting to the end, and I will pray that we will all finish and do everything successfully, inshallah. Amen.
All right.
Amen.
Thank you very much for that prayer. We are grateful. We are grateful. So we will. Okay, can you confirm if you can hear me?
Yes, sir.
Okay, great. Thank you very much. So having said so, we will comment, and then you know, we are all Nigerians, and we want to start by saying the national anthem. I believe that we are. Okay, I can see my boss. Ms. Roscana and Kama. Okay. Mr. Barnabas, can you hear me now?
No, Mr. Barnabas.
Can you hear me? Okay. All right. Please, the other participants, can you confirm if you can hear me?
Yes, I can hear you.
Yes, we can hear you.
Loud
All
and
right,
clear,
thank
sir.
you. It seems
We can hear you, sir.
Mr. Barnabas has an issue with his device. I believe that other participants are all hearing me. I can see I don't know. Okay, yeah. You're welcome, ma. My boss, Ms. Roscana Ankerman, she's here with us. We're happy to have you here, ma. We're actually about to commence say the national anthem, then bring you on to give the welcoming speech, and then bring in our keynote speaker for the day. So please, can we say the national anthem after the count of 3? 1, 2, 3.
Right.
Compassion,
Dangerous
Nigeria for obeying. We love and I'll never be in
with heart and mind, one nation in freedom, peace and
we pray that the labors of our heroes past will not die in our time.
Amen.
Thank you. Thank you. With this, I will call on the chairman of the governing body, Mrs. Roscana Ankama, to give us her opening speech, and then welcome our keynote speaker for the day.
Thank you so much. Good morning, everyone.
Good morning, ma'am.
If you can, okay, good. You can hear me.
Yes,
It's
we can hear you, ma'am.
It's a beautiful day again. You're welcome to Shati Induction program for this year. This is the first program we're having this year with this induction. I would like to welcome all the new inductees into Shati Institute of Training. And I also want to appreciate all our please can we have our microphones muted if your microphone is can you please mute your microphone so that we can hear, so that we can minimize the background noise. Okay, thank you so much. I appreciate that. I want to thank all our supporters, our partners, our collaborators, and more especially our keynote speaker this morning. Prof has always been available anytime, any moment, and any day we call upon him. He is always backing us up. We're so grateful, sir, for your commitment to Shati. I also want to use this opportunity to encourage all of us to listen carefully and attentively this morning before the induction as we take this keynote charge. And I know that by signing in ADR, you have taken a path to prosperity. Because with ADR, you will be able to function properly, not only in your place of work, not in your place of career professionally, but even in your day-to-day activities. Your body, your spirit, your soul, you will keep aligning it together for peaceful coordination. And I believe that as you go out as ambassadors, you're going to put your input on the table, and it is going to enhance productivity wherever you find yourself. I would like to welcome you this morning to this induction, and I would like to encourage you to be attentive and take home valuable lessons as we listen to our keynote speaker. Our keynote speaker, Prof, you're welcome, sir. Thank you very much. I also want to thank the CEO for always being very active in his coordination, even when the chips are down, even when you think that nothing is going to come up. Our CEO is the person that does not believe there is an impossibility. All he needs is give him the opportunity and he will show himself. I want to appreciate you so much, CEO, for doing that. And I believe that you will have more insights and you will have more grease to your elbows. Thank you very much and welcome everyone.
Thank you so much. Nancha, you are muted.
Oh, so sorry. I thought I thank you very much. Thank you. I really appreciate. Without waste of time, we have with us distinguished personalities. We have Sharia court judges, we have hadiths, we have customary court judges, we have legal practitioners, we have registrars of court, we have FIDA chairpersons, all over, and we have our very own Ambassador Shegun Niriam here with us. We cannot be more excited than this. I'm sorry, I've not introduced him. He's actually here. Our chair, Ambassador Shegun, is here with us, and we actually recognize your presence here. Thank you very much. Without time, okay, sorry, ma. Will you want to say something?
Yes, Ambassador, you're welcome. Thank you very much. I didn't know he was already here with us. Thank you for honoring our invitation and being part of us. We're honored to have distinguished personalities amidst us, and it's a plus. Thank you so much.
Thank you very much. Thank you.
Thank you. Thank you. Thank you. I appreciate you all. Thank you. Thank you.
Yeah, okay, thank you very much. Having said so, today we are blessed to be to have the distinguished presence of our lead speaker for the day, in person of Professor Olajide Olagunju. He is a lawyer who has been practicing for over 30 years. He's also an ADR practitioner of that number of years. He has contributed to the development of law, ADR practice, in multi-door court houses, all over the world. We're actually proud and privileged to have him here. I will just introduce him briefly because I cannot read all his profile. So, but I will just introduce him briefly for the purpose of this so that the participants and the inductees will get to meet him. Professor Olajide Olagunjo, he is a fellow of the Chartered Institute of Arbitrators, United Kingdom. He's also a fellow of the Institute of Chartered Mediators and Conciliators. He is an anthropologist. Anthropologist is a peace scholar, is a lawyer, he is an arbitrator and a mediator. Is a Harvard University Research Fellow and a Brandeis University Research Scholar in Conflict Resolution since the year 2008. He is a Mellon Research Scholar in management of internally displaced persons, Boston Inter-University Committee on International Migration, 2001 U.S. government international visitor to preventive diplomacy and conflict resolution, the 2008 UN Australian government scholar in international civilian peacekeeping. Is a peace builder. Is a post-conflict reconstructor. He is a British government Chevron scholar in emerging law and alternative dispute resolution. He is he is someone who speaks different languages, especially he's fluent in both English and French. And he has written a lot of books that have contributed to humanity. I believe that some of the books he's going to advertise it here for those who may be interested. He has written, he has over 50 publications to his credit in about 27 languages. He has written on how to resolve a conflict. He is a winner and he is a winner, best mediation book of all times. You can see this is the personality of the person we are privileged to have to speak to us. And as you know, we are going to be speaking, we are going to be considering a very important topic, especially as mediators. what in Nigeria and the world at large. So will you join me to welcome our speaker for today, Professor Olajide Olagunju? So before I hand over the podium to him, I don't know who can remember our topic, what we are going to be discussing on today. Can somebody? Can somebody say it? Our topic for today? I don't know.
So the topic is effective justice delivery, the role of the mediators and the bench.
Oh, thank you. Thank you very much. It means that we are all together. Prof, sir, before I go ahead, I have another distinguished personality amidst us. I can see a senior member of the bar, as well as the ADR practitioner, the convener of the Association of Multi-Door Courthouse Practitioners, in person of Mr. Valentino Boro. Please, sir, you are welcome. I don't know if he is with us. You're welcome, sir. Thank you for joining us. Having said so, Mr.
Thank you, Nachan.
Oh, you're welcome, sir. Thank you very much. We're happy to have you here. So, Professor, sir.
Yes, thank you so much. Thank you so much. Good morning. Good morning, Mrs. Ankama. It's such a joy to see you again. And thank you for having me. And of course, Nanchang, thank you for doing such a great work at Shati. I welcome my friends. They're already arriving. My brother Valentino, my brother Shegu. There are others who are in my network. I may not recognize their name. I welcome you all.
Thank you so much.
I'm going to ask my friends to come. Some of them don't speak English, so we're going to have done the speech in English and French. That's the best I guess I could do for within the time. And others who may not understand English or French would manage with us. I told them I was speaking at 10:30, so some of them may just be coming in. I welcome my brother, but my two brothers and friends who are already here, and anyone that I have not seen their names. It's such a joy. It's such a huge joy to be here. Of course, Nigeria is very, very dear to me. And of course, mediation is dear to me. And Shati is, of course, very dear to me. Thank you so much. Before I go on, I want to congratulate to these graduates inductees. It's such a joy to have more mediators. I don't think you can ever have too many mediators, because the number one industry in the world is conflict resolution. So we need as many people as possible. So see yourself as very, very important. Having said that, I want us to go into what I want to say. I've written it down, and I would like us to read together, and then we can discuss afterwards. The people who speak French, they would be able to read along. As I'm reading English, they can read in French. I'm going to share my screen now so that you can all see. God bless you, and I'm very happy that to be with you for the invitation. And Nanchang, I appreciate the introduction. That was a very good one. Now, so let me share the screen, and then we can start.
Thank you, sir.
It's my pleasure. Okay, I've seen it. Okay. One second, I want to make sure that I can see the screen very well. Okay. Okay. So like I said, I'd like us to read together and then we can discuss afterwards. Well, I already did the protocols, I greeted you. I particularly, of course, need to appreciate the judges in the house. I celebrate you. The judges are mostly always first, of course, lawyers. So we're all members of this legal profession. It's so nice to have you here. Now, so effective justice delivery. I hope everybody can see my screen.
Yes.
Good. Effective justice delivery, the role of mediators and the bench. It is probably correct to say that I introduced mediation as a professional practice to Nigeria with the registration and work of Corporate Mediators Kaduna in the summer of 1995. Another organization called EDR Limited was registered in 1994, but I doubt if it went beyond the registration into actual practice. Stand to be corrected. What is certain is that professional mediation practice in Nigeria began in the early to mid 1990s, and I was privileged to be one of the pioneers, which is probably why I have the privilege of speaking to you today. The point I am trying to make is that I think that after about 30 years, I can know what works and what may not work in the mediation industry, into which we are formally and warmly welcoming most of you, our new colleagues today, through the agency of our fellow mediators at Settlement House ADR Training Institute, Shati. I say all that to say that I wish that when I started mediation practice close to 30 years ago, someone had told me what I am telling you today. So I hope you will make my scars your stars. I will use an old story to illustrate the point I just made. It happened in Kaduna about a quarter of a century ago. The chief judge of Kaduna State at that time, and for a very long time afterward, was Honorable Justice Mrs. R.H. Kujo, OFR, a quiet but great woman by all standards, and notably a great judge. I should know that because I appeared before her after my call to the bar 36 years ago. 5 years into my legal practice, the government of Britain made me a Chevening Scholar, which enabled me to specialize in mediation while studying at the University of London. Since I left Kaduna for the postgraduate program in England, I naturally returned to Kaduna to establish my mediation practice. Being a responsible and responsive chief judge who also had foresight of the relevance of what we now call a multi-door courthouse, the learned and revered chief judge graciously offered to give me a room in the High Court to start what would have been the first multi-door courthouse in Nigeria. The Bible says we must not despise days of little beginning. Regrettably, being a young and relatively inexperienced mediator, I failed to utilize the offer. I was rather thinking and dreaming of big international grants and a big multi-room mediation center. I thus failed to see in that small room office the seed of greatness then of my budding mediation practice. And because I did not discern my day of little beginning, I lost a strategic opportunity. And I can inform you for free that my dream of securing a big grant for a gigantic big mediation center with many offices did not see the light of day. It reminds me of the story of Nigeria as allegedly told by head of state, General Yakubu Gowon, in the early 1970s, to which it was alleged to have said that Nigeria had too much money and our problem was how to spend it. Of course, Nigeria seemed then to have too much money because of the nationalization of petroleum in the fall of 1969 by the general's military regime, which legal theft diverted the wealth of the Southeast and South-South to national coffers. The government was trying to build Nigeria from the top down, as they are still doing today. They have been trying for 55 years to grow the country in a big way. But only the day of little beginning makes anyone or institution, including local and national governments, great. Trees only grow bottom up. Nations only grow from grassroots politics up. And big mediation practice, which we are all believing for, and which I guess some of you are also thinking of, which is okay, like big law practices or any professional practice, only grows from one little office up. Otherwise, they crash. Just as Nigeria did, at least one effect of which I know firsthand. I recall that I exchanged 65 kobo. I'm sure many people have forgotten what kobo is. Kobo is a fraction of the naira. I exchanged 65 kobo for $1 in 1976. But now, in the last year, I needed between 1,500 and 2,000 naira to get the same $1. By the way, many years after I failed to effect the first judiciary mediator alliance and collaboration that would have bettered Nigeria and probably Africa's first multi-door courthouse in the Kaduna High Court, the Kaduna multi-door courthouse happened and is thriving without me at the same High Court. I therefore owe the very graceful and gracious Justice Kujo an apology, although I'm sure she has forgiven and forgotten my sin of youth. Join me in wishing her health and strength in retirement. And to pay back Kaduna for what I should have done 27 or so ago, I look forward to running a mediation training for Kaduna multi-door courthouse in my lady's honor soon. When that happens, I hope people will attend from all the nooks and crannies of Nigeria. And that includes those of you listening to me now. Maybe Shati would make that happen. Why did I tell that decades-old story? Very simple. The best friend of a mediator is a judge. Our best friends as mediators are the bench, I think the judiciary. While you may need to market your mediation trade to a lawyer and sometimes to litigants, both corporate and individual litigants, it is not the same for judges. The reason is not far-fetched. It is at least threefold. Judges have tenure, so they can afford to go for the best. They naturally want an efficient justice system, which can only be enhanced by the infusion of amicable dispute resolution. Can somebody please mute anyone who is not talking so that I'm getting this distracted, please. They also, forgive me. So I'll go back to where I stopped. I was given 3 reasons why judges are our best friends as mediators. I said judges have tenure, so they can afford to go for the best. They naturally want an efficient justice system, which can only be enhanced by the infusion of amicable dispute resolution epitomized by mediation, which is our forte into the judiciary. They also have empathy. They see cases and appreciate that often the parties only need an opportunity to settle amicably, which is our business again as mediators, taking disputants to resolution and often restoring parties' relationship, which is at the root of the conflict in the first place. Judges also understand time management. In fact, in Nigeria, it is right to say that judges are often overworked by case overload, which overload could be reduced if they have the opportunity of the services of mediators like you and me, working with them to offer alternative dispute resolution, notably mediation. Let me share here my thoughts on the institutionalization of mediation, which is critical to the promotion of justice through the intersection and collaboration of the justice system, aka judiciary, and the amicable dispute resolution system, aka ADR, aka mediation, aka conflict resolution. In doing so, permit me to lean on and glimpse from chapter 8, beginning on page 70 of my book, How to Resolve a Conflict. The chapter is titled Institutionalizing Mediation. I begin with a quotation, talking about the book, from the state of Texas ADR, which provides as follows. It is the policy of this state to encourage the peaceable resolution of disputes, including the mediation of issues. It is the responsibility of all trial and appellate courts to carry out this policy. I then list several areas where institutionalization could and should happen. I go on to discuss how various bodies in society can promote the use of mediation. First, I mentioned the state and wrote as follows. The state is well placed, forgive me, to promote the use of mediation. This may be achieved by providing proactive legislation on mediation, as several governments have done. I already cited the one from Texas, the law on mediation. In addition to legislation, the government could also make provisions in the court rules for reference to mediation in appropriate cases.
Oh, yeah, excuse me. We have volume.
Okay. I wish somebody could mute.
Which one is normal volume? Which one do I know?
Please. France did this in February 1995. Facilities could also be provided for mediation in the court premises to ensure easy access to mediators. This is being done in the USA. Apart from the mediators recognized by the federal and state governments in the US, the various governments in the USA also have official mediators who go to institutions where they are needed to mediate. China and Canada are also very active in this respect. The compulsory settlement proceedings that was pioneered in California in the 1970s could also be adopted, in which a week is set aside every year when parties are required to try mediation. And I say it's been successful. I'm aware of similar things. I'm aware, forgive me, similar things are taking place in Nigeria. from the pioneering work of the Lagos State Ministry of Justice, especially under my learned senior friend and respected brother, Professor Yemi Osinbajo, SAN, which pioneering work I supported for all the 8 years he was Attorney General of Lagos State. In this, the center there called Citizens Mediation Center, CMC, backed with legislation enacted by the Lagos State House of Assembly, got its name from me, thanks to the listening and wise ears of Attorney General Yemi Osinbajo, SAN, GCON, who later wrote to be Vice President of Nigeria, as you are all, or most of you are aware. CMC used to be called Citizens Arbitration Center before I joined a team of volunteer consultants that the then Attorney General Yemi Osinbajo assembled in 1999 to help create a more robust Ministry of Justice for the great people of Lagos State. We also know how well the judiciary of Lagos State fares because of the pioneering innovation and initiative of that great mediator, Professor Yemi Osinbajo. Now, back to my book. I speak of lawyers' role in the institutionalization of mediation practice. I wrote as follows: Lawyers Association could also lead in the promotion and provision of mediation facilities. Australian lawyers are pioneers in this regard. The American Bar Association and the Law Society in England have done a lot of research on the promotion of mediation. In-house solicitors, company secretaries, and legal advisors ought to consider introducing the directors and managers of their companies to the concept of mediation. This will help them to deal effectively with both external and internal conflicts, thus ensuring a firm management control of business disputes and avoiding bad publicity. Then I speak about how corporations as companies can help institutionalize mediation. I write as follows: a good manager today must also be a good mediator. I hold the view that it is not difficult for an executive to learn to wear the cap of a mediator. The manager is already skilled in one kind of negotiation or another and utilizes this negotiation skill in his day-to-day work. To acquire and apply mediator skills, the manager reorientates himself to use structured, party control, non-adversarial, non-competitive, and non-coercive negotiation techniques, which is what mediation is all about. I discuss various techniques, particularly my 2 original contributions to mediation skills in chapter 6 and 10 of the book. That's how to resolve a conflict. I also speak about how mediation clauses can promote mediation institutionalization. I write as follows in the book: one way of ensuring easy access to mediation in times of conflict is to provide for it in advance when signing any agreement or contract. An example of a mediation clause would be the following: the parties hereby agree that in the event of a conflict arising from this agreement, the parties shall, in good faith, undertake a speedy resolution by reference to a mediator under the attached model mediation procedure rules. Where, in the situation where a dispute has already arisen, the following format is suggested: a dispute having arisen between the parties in respect of, we describe the nature of conflict, the parties have agreed to attempt an amicable and confidential resolution by reference to a mediator under the attached mediation procedure rules. Of course, the model rules I'm talking about is at the back of the book, so they just need to make reference to it. I go on in this heading to submit as follows: it is important to remember to state the mediation procedure rules that will guide a mediation, because in some jurisdictions, it is required that the procedure governing the mediation is described in the agreement to mediate. for the mediation clause to be enforced when the need arises. I also speak about how corporate dispute prevention and management policies may be crafted and adopted to promote the institutionalization of mediation. I write as follows. Mediation could also be promoted by various organizations. One way of doing this is by providing for mediation in their charters. Also, organizations that already have provisions of mediation in their charters could make use of it for members and parties' conflicts. The French Centre d'Arbitrage Rhône-Alpes, CARA, is one of such organizations. I want to emphasize that various organizations, be they social, political, economic, government, or non-governmental, could play a great role in the prevention and management of both internal and external disputes. Conflicts will then become a challenge and an incentive for better relationships and not the nightmares that they presently constitute worldwide, with the possible exception of Japan, where mediation has become synonymous with good organizational practice. When organizations adopt the proactive role proposed here, the weakness complex, as well as the brinkmanship and loss of face, loss of money and waste of time, uncertainty, bitterness, and rancor, which are embodied in violence, litigation, and arbitration, could be effectively sidestepped. Those members who cannot rely on a personal arrangement for mediation could simply fall back on the policy put in place for them by the organization. And I give an example. I drafted here what could be a policy that the whole government will adopt for their country, for their state, organizations, chambers of commerce, whatever people have in groups. An example of how the policy could be shaped. Let me just read the body of the policy, of the proposed policy. Dispute prevention and management policy. Recognizing that in every human interaction, conflicts may arise, and that discussing and using voluntary conflict resolution methods can often resolve conflicts amicably and at much less cost than adversarial processes. We pledge to work to prevent disputes by making effort in good faith. 1, to consider establishing appropriate dispute avoidance and conflict resolution procedures when entering into agreement. 2, to explore the early resolution of conflicts through direct discussions, mediation, or other voluntary conflict resolution processes before considering litigation, arbitration, and other adversarial methods. We further pledge to make this policy known to all our members and the public. And the president of the organization or the state, country, whatever, only need to sign and becomes a policy. Now, to realize the objectives of this policy statement, training for in-house mediators could be arranged so that the organization could mediate conflicts from various members and branches. For example, an economic organization such as the Chamber of Commerce could train and maintain specialist mediation panels, e.g., construction mediation panel, bankers mediation panel, securities and finance mediation panel, oil group mediation panel, etc. For a political organization such as a political party, they could have mediators for various geographical areas, e.g., city/council mediators, regional state mediators, and federal or national mediators to deal with internal and external conflicts at various levels. The obvious advantage, apart from the concrete realization of the policy statement, is that individual members would have access to mediators easily and timely. The organization will also be largely able to maintain firm control over conflicts that are of interest to its well-being, both from the perspective of individual members' welfare as well as at the organizational level. Such a policy statement would not foreclose the members' rights to obtain urgent legal relief before the commencement of the mediation process. Furthermore, lawyers could take part in mediation. The process of mediation has room for robust advocacy, although not for antagonistic arguments and fault finding. I then go on to describe how a conflict resolution system design can also be used to promote mediation practice. I write as follows. Conflict resolution system design is simply an organization's formalized way of dealing with internal and external conflicts. At the moment, most organizations do not seem to have such a system in place and only deal with conflicts as they arise. This lack of design amounts to inefficient conflict management with its consequent setbacks and losses. Where, for example, the labor and management of an organization have agreed that in times of conflict, they would take specified steps and procedures before resorting to adversarial methods, the organization is likely to enjoy industrial harmony. We are not here referring to a legal compulsion to use the specified system, but a conscious, deliberate, informed, and unanimous agreement by the rank and file to use the conflict resolution system. To implement a conflict resolution system design, in-house mediators drawn from the rank and file could also be elected and trained. External conflicts could also be subjected to an organization's conflict resolution system, especially when dealing with customers. In this case, it will be ideal for organizations to include in all their agreements that the conflict resolution system applies to the transaction. In line with the foregoing submission, I recall that when Nigerian Electricity Management Services Agency, forgive me, agency should be there, NEMSA Act 2015 was still on the drawing board. The opportunity, let me just correct it right away. When the act was still on the drawing board, the opportunity was seized. I apologize profusely, forgive me. The opportunity was seized to include the use of amicable dispute resolution in that law. It is now enacted as section 14.5 of the NEMSA Act as follows. In resolving disputes, including intra-organization conflict and external conflict involving any person or establishment, the agency shall, as first line of action, apply amicable settlement processes, such as negotiation, mediation, and conciliation before resorting to the court. This provision, being part of the law setting NEMSA up, makes it easy for conflict in and with NEMSA to be effectively, amicably, speedily, and cost-effectively resolved. A similar provision has existed for ages in the Trade Dispute Act of Nigeria. I'm sure that country would have similar Trade Dispute Acts, but it would seem that it is not made use of as it should be. Hence, a lot of labor disputes are not effectively managed. It is, of course, the business of us mediators to leverage the opportunity of the lacuna. And I hope you, my colleagues mediators, are listening. As I'm reading this again, I'm seeing a lot of opportunities, and I'm sure you've seen that. All you need to do is take notes and say, oh, how can I use my skills that I've achieved in Shati as a mediator to go and earn myself some living, no matter how small, in all these many thousands of organizations that will need my services. I've given you an example now, somebody helping NEMSA to put into their law a conflict, an effective, amicable conflict resolution mechanism. Also in this respect, I'm back to the paper. In this respect, the Constitution of Nigeria, as amended, robustly empowers the National Industrial Court of Nigeria to use amicable dispute resolution mechanisms. Again, it appears that not much effort is made to leverage the opportunity by both the judiciary by the judiciary at that level. Mediators also need to go in there and help this court implement the law. It is easier in many respects to practice mediation today compared to 30 years ago when I started. But every opportunity demands and requires diligence and keen eyes to deliver its promise. I also submit that another way of promoting mediation is by setting up a mediation center. I have already mentioned above Justice Kudo's foresight in promoting this approach by proposing the establishment of such a mediation center at Kaduna High Court about 3 decades ago. In the book under reference, I write as follows: governments, trade unions, and NGOs could also establish either fee-paying or non-fee-paying mediation centers, such as the many such centers that have been established in China and the USA. These centers sometimes rely on volunteer mediators who are trained by the centers in return for providing mediation for disputants who use the centers. The staff of the center could be as small as one clerk or manager who receives complaints, invites disputants, and directs them to a mediator. The experience of the Lagos Citizen Mediation Center, CMC, indicates that when such a center is seen as an arm of government, in this case, part of the Justice Department of Lagos State, it commands the respect of parties. Because of its novelty, government participation in the establishment of mediation centers in some countries may help the growth of the process. I say this against the view of some colleagues who are rightly of the view that the environment in each country will determine the way mediation is introduced there. What is certain in the Lagos case is that people's respect for the institution of government seems to make them agree to come to mediation. And the rate of disputes resolved at the center has been very high, and most cases settled. And then go to describe how teaching school children to mediate can also promote mediation. I write as follows: in the USA, peer group mediation has proved successful. It involves school children mediating between fellow children. I hope this practice will soon become global. It will also be useful for if peer group mediation were peer group mediation. So it should not be where, it should be is. Okay, forgive me. Is popularized in universities and other institutions. I also spoke about mediation training and advocacy, how it can help institutionalize mediation practice. And I write as follows: Chief Justice F. Yalali of Tanzania, a respected mediation scholar, believes that the inadequacy of judicial systems worldwide is directly traceable to the emasculation of traditional mediation. And I believe that very much. I've taken a lot of time to study traditional African dispute resolution mechanisms, and it's amazing what our ancestors have for us that we are not making use of. He believes that every human community has enjoyed the use of mediation at one time or the other before succumbing to litigation. He has therefore called for important reforms, including the introduction of mediation studies in the training of young lawyers. Just Yalali also wants to reform in the professional and trade unions to enable them to mediate conflict among their members, irrespective of the nature of the conflict, so that non-trade disputes can also be effectively settled by the unions and professional bodies. Other jurists, including Nigeria's former Justice Mohammed Bello, of course, Justice Yalali is also former. I should have put that there. Justice Mohammed Bello and the French colonial judge André P. Robert and Canada's Justice Blenus Wright have argued that the only virtue of a legal system is its relevance to the community. With regard to the need to include the concept and practice of mediation in the training of young lawyers, the Harvard Law School has taken a lead. Many other American law schools also teach mediation. I know that Nigerian law school is not lagging in this respect. I remember giving the Nigerian law school pioneer special lecture on mediation in August 1996. Those of you who were in law school at that year will probably remember that lecture. The law school went on to name my first mediation book, Commercial Mediation, an Alternative Dispute Resolution ADR Mechanism, 1998, its first mediation textbook. I also gave the first lecture in mediation at the Nigerian Institute of Advanced Legal Studies in April 1996. Back to my book, I finally write about our colleagues in the legal profession as follows. I now strongly believe that lawyers and other professionals in conflict resolution should take an active part in the adoption of mediation in conflict resolution. I think if we do not take part in this move to take justice out of the overheated courtroom, society will eventually render us redundant. I am hopeful that we will meet with this challenge. Now, what is the importance of all this tour de force around mediation institutionalization vis-a-vis the topic of today, namely effective justice delivery, the role of mediators, and the bench? The answer is not far-fetched. In this day and age, no one can deny that an effective justice delivery system in any country is tied to the strength of its mediation or ADR institution. The judiciary, more than anyone or any other institution, knows this. But judges are not mediators. So they cannot play the role. So they see the need for all. They see the need for mediator, but they cannot go and be doing the mediation. That is not their duty. Therefore, it is right to say that for the justice system to function most effectively towards the delivery of a robust justice for the citizenry, the judicial institution and the ADR institution, aka mediation practice, must work very closely together. I already see that happening in the last 30 years of ADR and mediation in Nigeria, and I'm very pleased and fulfilled to see that salutary close relationship continue to blossom so that justice could truly reign in Nigeria. I salute all the judiciaries at all levels in Nigeria who are making this happen. I encourage those who are not on board the mediation and ADR train yet, if any, to quickly do so. It is the future of justice delivery, especially for a developing polity like Nigeria. Effective, trusted, avant-garde, reliable, and speedy justice system, which is tied to mediation, attracts direct foreign investment, DFI, and makes good business to flourish, which in turn creates employment for youths and thus make peace possible, given that violence cannot exist when there are no idle youths to start, fund, or maintain it. You need a strong girl, a strong boy, a strong man to fight. So when all our youths are gainfully employed because the industry is thriving in the country, of course, there will be nobody to go and use to start unnecessary fight and violence. Finally, I encourage mediators, including those in Shati, our host today, and particularly our new inductees, to continue the good work. There is a lot of room for initiative, innovation, and improvement, especially in ensuring that our services as mediators are mainstream in the courtroom. Thank you so much. I bless you. I will stop the screen sharing so I can see your faces. Okay, that's it. Over to you, Nanchang.
Thank you very much, sir, for that wonderful
you are breaking. Maybe you should take off your maybe you should take off your camera. Maybe you take off your camera so that we can. Now you are breaking. You can switch off your camera so that it will be you can hear you.
Okay, sorry. Can you hear me?
Yes.
Thank you. Thank you very much. So thank you very much to our distinguished speaker for that wonderful keynote address. That's actually wonderful. And for the inductees, if you have listened, he has actually deliberately touched different areas within the short period of time that he has in order to deliver on the topic that was presented. Without a waste of time, I will like to call on few persons who are here with us. We are privileged to have them maybe add one or two things to what has already been said to share their thought on this aspect. And I don't know if Ambassador Shegun is here with us, if he may want to share a thought on. Thank you very much, sir. Okay, sorry, because of the noise, I had to mute everybody. Some persons, due to one thing or the other, get their microphone on. So I'm going to allow everyone to.
Thank you. Thank you.
Thank you.
Thank you very much. Thank you. Three things I will say very quickly. The first is to thank His Excellency, Professor Olajide Olagunju, for that resplendent delivery. I want to put on notice today that Prof remains one of my mentors in the field of mediation. Indeed, it was his book, The Corporate Mediators, that was the first book I ever read about mediation. Before then, I didn't know the difference between mediation and arbitration. Your Excellency, you are a great man, and I celebrate you exceedingly.
Thank you.
Thank you for your pioneering work.
Thank you, sir.
Two, Prof had said he regretted not taking advantage of that small office in Kaduna. He was looking forward to having a bigger sponsored office where he can practice what he believed in. Your Excellency, that actually happened. Your vision for a greater office actually happened. I had the privilege of writing the proposal for the establishment of a Lagos multi-door courthouse. And we got funding, $50,000 from the US Embassy. It was because I read your book, sir, that was possible. So you actually must rewrite history that the establishment of the Lagos multi-door courthouse actually came through you. If I had not read your book, that would not have been possible.
Thank you.
The Apostle Paul in 1 Corinthians 3:6 said, I planted, Apollos watered, but God kept making it grow. It was the seed you planted in me that made that possible. You're a great man, sir. Thank you. The third is about the topic. Justice Sandra Deokuno says that the courts of this country should not be the places where the resolution of disputes begin. It should be the places where disputes end, after all means of resolving disputes have been considered and tried. That is the role of judges. That is the role of judges. Justice Dolakpa Akinso has said that sometimes cases emanate from lower courts only to get to the Supreme Court, and they be sent back to the court of first instance to be heard all over again. At the end of the day, the parties are exhausted, embittered, and impoverished. So judges can help the system. Finally, on this, Chief Justice Warren Boga clearly said that the notion that people want black-robed judges, well-dressed lawyers, and fine-paneled courtrooms as a setting to resolve disputes is not correct. People with problems, like people with pain, want relief, and want it as quickly and inexpensively as possible. So judges have a major role in encouraging litigation. Once they do, because the parties, the lawyers believe in the judiciary, they will respond appropriately. Once again, Your Excellency, thank you for that resplendent delivery. You are a great man, and I appreciate you. Thank you.
Thank you. I celebrate you too. I celebrate you. Thank you so much.
Thank you. Thank you very much. Thank you very much, sir, for that wonderful contribution. We're happy to have you. While we look up to you as our mentor, you also have someone you are looking up to, and then we have the privilege of tapping from both of you. We are really, really grateful. In your words, sir, I will say you are a great man. And we appreciate you.
Oh, you know,
Thank you very much, sir, for that wonderful contribution. And I can see our senior colleague and the convener of the Association of Multi-Door Courthouse Practitioners. Sir, Mr. Valentino, you can share your thoughts with us on the topic.
Because we use
Let me begin by thanking the professor for a very impactful lecture. He's touched on so many areas of dispute resolution and the justice delivery system. But when I talk about the judges, the role of judges and mediators, I sometimes want to look at it from the very primary level. I want to look at it from the justice family, justice delivery family. Let us have this kind of a mental picture where you have a family of a father and a mother, and of course the children. Justice, as we know, the judicial system has the power of coercion, authority, and has been the first in time. Mediation has always been there, but with a less formal appearance. Now that both mediation and the justice delivery system are together, people should not, particularly lawyers, should not see mediation or ADR as a threat to the sustenance or the continuity of the judicial system. Rather, ADR, through its flagship of mediation, complements the judicial process. Like the father of a house, the judges and the courts have the authority and the power of coercion to discipline when the children of the house go wrong. Mediation or ADR as the other side, which I want to represent with the figure of the mother, is always available to look at things from the subtle way, but in such subtlety that is very, very deep. If you understand the relationship between a mother and a child and how most children will take on the instructions of their mother without the use of coercion, you can also understand how people may buy into mediation, not because of coercion, but because of an understanding, because of love, because of that soft touch, which is nonetheless sophisticated. Before I sign off, let me say to your graduates that mediation at this primary stage is still a business in search of customers. If you are a business person, you should know that there are two types of businesses. The businesses that customers look for and the businesses that look for customers. At these early beginnings, mediation is still in search of customers. So the burden is upon all of us, both trainers and trainees, to take the message to the whole world, to take the message within our national boundaries, to educate and empower people on what mediation is all about. Though it is fashionable for people to train and be looking for employment, the employment opportunities are rare. You have to build your own by reaching out to your various publics. How do you market? To your immediate environment, to your church, to your friends, to your family, to educate them on the presence of ADR. And so, like the Bible says that the harvest is huge, but the laborers are few. So also, we will need more people to go into the system to educate Nigerians and all other users of the mediation process that this is the way to go, an option. Where it doesn't work out, then you can resort to litigation. And those who are in litigation, when the process is on and appears to become rather slow and cumbersome, you can refer to mediation. So it is complementary. So I congratulate you once again for the journey of having taken this course, and I wish you the very best. Thank you very much.
Thank you. Thank you. Thank you very much. It is actually very instructive to listen to the words of elders. And as our elder, Mr. Valentino has given us on a platter of gold the necessary advice that we need, both for those that are on the bench and those newly inducted mediators. Mediation and ADR generally is an emerging, though it has been with us for a long time, as Antino has said, but a lot of people are not aware of it, and this ignorance is not limited to those the consumers or those that are in need of these products. It also affects lawyers, because you can see a lot of lawyers who are actually ignorant of the use of ADR. I was opportune to mediate a matter where a lawyer on the other side filed a notice of preliminary objection to a request for mediation that was before, before the for settlement, and he filed a notice of preliminary objection. And what do you expect? He's doing his work as a lawyer, and the best thing he knows is that when something doesn't seem right, and he feels that there is no jurisdiction, he files a notice of preliminary objection. So you see a lot of lawyers who are ignorant of the use of alternative dispute resolution, even though this alternative dispute resolution is actually part and parcel of our rules of professional conduct as lawyers and legal practitioners. If you look at section 15 of 3D, you see that a lawyer has this professional responsibility to ensure that his client advantage of APR before after resorting to litigation. So it's actually a professional responsibility. So some of us are trained today making that, oh, okay, now I'm a mediator. When I someone with me say, if I finish doing this course, where am I going to get this and that? And I was like, that is it. When you finish from the university and you have graduated, you have your certificate, you go in search of. Through this training, you have learned a lot of skills, the ability, you have done emotional intelligence, you have done a lot of other courses, including negotiation skills that will help you in your day-to-day activities. I would like to say that it is now left for you to see from all that you have acquired, couch a niche for yourself and begin to pursue it. For those that are on the bench, you are already strategically placed there. In one of the seminars we organized for the Sharia court judges, Sharia court judges and the Qadis, sometimes back last year, we got to understand matters that come before the judges. Once they are able to resolve these matters, it is not as though I've helped them to settle their matter, and there is no credit that goes to me as a judge. We learned that is not the position. When you help parties resolve their dispute amicably, after being the resolution, they are going to draft their terms of settlement and they will bring it back to the court, and you are going to adopt that. Terms of settlement as consent judgment. And once you are able to adopt that as consent judgment, it becomes one of the judgment of the court, and the court has the power to execute. And the court is going to, the judge is going to include that matter as one of the matters he has handled in his court. So you can see the synergy between this newly profession that we call mediators or APR practitioners and then the court. So mediators, you always find this collaboration where if you need to go to the multi-door courthouse or you need to go before the court, you bring out your skills, ensure that your client gets the best so that within the shortest time possible, you get your client resolve his matter as quick as possible. And when you're able to do that, you file terms of settlement, and people will be wondering tomorrow, as against popular opinion, that when people begin to adopt mediation, then the job for lawyers will be no more, or it's going to amount to reduction in their revenue and all of those things. I hold a different opinion. I believe that as a lawyer, if you help a client resolve his matter within the shortest time possible, he is going to see and he can make reference, he can refer a lot of solution and the those on the bench, the Sharia court judges, the customary court judges, the Qadis, all present in this induction ceremony. These are things that we can do, and by the time we know your court at court where settlement can be done as quick as possible, I believe that people will have preference to make sure they can have justice in time, and then parties will get involved in resolution of their dispute, and they will be very, very happy about the outcome, which most times you don't need to go and enforce because the parties are really involved in the ceremony. Thank you very much, Mr. Valentino, for that wonderful contribution. We are grateful to you. And in the words of Ambassador Shegun, I will borrow those words to say, you are a great man, and we really appreciate you and your mentorship. Thank you very much. Now, having said so, I don't know if any of the participants has any question that you want to be addressed in the presence of this personalities that we have media practitioners here. If you have one or two questions that you want to be addressed before we go into the induction proper, please kindly raise your hand, and then you will be given the opportunity to ask as quick as possible before I hand over to my boss, Mrs. Ankama. Okay, Precious, do we have any question? Okay, I will assume that we do not have any question, and if that is the case, I will want to appreciate our keynote speaker. Let me hand over to my the chairman of the governing body, Mrs. Sultana Ankama, to appreciate our speakers and contributors. I said, if we have another person here who will want to add to what has been said, I will really appreciate.
Yes.
Okay, we have Mr. Felix. Mr. Felix, please.
Can you hear me? All right, thank you so very much. I'm so grateful for this opportunity. I want to say first and foremost a big thank you to the learned prof for that erudition. My only contribution is in the area of one of the points she has actually made in relation to the role of the judiciary or the bench to this mediation. I'm a senior lecturer in law in one of the universities here in London, and I've been a practitioner here as a solicitor, and I understand the role that the bench plays in this area of mediation. For example, we have the case law of Hassey and Milton Keynes General NHS, which has been a court of appeal decision since the year 2004, which is to the effect that parties could not be forced to engage in mediation, as that would breach their right to a fair trial under Article 6 of the European Convention on Human Rights. And that kind of limited the role of mediation to an extent, in that the only contribution it makes is that if you fail to involve or explore the option of alternative dispute resolution, it will just attract cost, and that the court cannot mandate you to take part in mediation. But interestingly, a few months ago, in a recent case, the case of James Churchill and Methyl Tidal County Borough Council, is reported in the 2023 England and Wales Court of Appeal Civil Jurisdiction at page 1416, is to the effect that parties would need to actively consider alternative dispute resolution. An interesting thing here in the UK, where you mentioned ADR, what you are talking about is simply mediation. So what the Court of Appeal is saying in essence is that parties will need to actively consider alternative dispute resolution options before taking claims to court. And that's very important, and that's a very welcome development for mediation. Now, judges can pause legal proceedings or other parties to take part in non-court-based dispute resolution process, which is a welcome development. And I believe that if we have such decisions in Nigeria, it will also go a long way to promote this issue of mediation. I want to say thank you so much, and thank you again, my learned professor and mentor. God bless you real good.
Thank you. Thank you. God bless. I'm glad to see you, Felix. Such a joy.
Thank you. Thank you very much, Mr. Felix. We really appreciate that contribution. And if you don't mind, I will plead that you help us with those cases, the two cases you cited. I will really appreciate to have that. And then the inductees, I believe I'm speaking for them. You can help us drop it on the chat. and then I will drop my contact before I can get it across to them. We really love to have it. Thank you very much. In the absence of any other contribution, may I hand over to my boss, the chairman of the governing body, Mrs. Rosana Ankam.
Thank you very much, Prof. Thank you so much, Ambassador Shegun. Ambassador Shegun was my teacher in Abuja before I went to UK for CEDA training. I hope he remembers me. Thank you so much, Sir Felix, for that. And I know CEDA has played a very pivotal role in the UK to ensure that mediation comes on board. And we here in Nigeria, we have been doing our best to ensure that mediation takes the center stage in dispute resolution. And I will always—
Sorry, ma, we can't hear you.
You can hear me?
We can.
We hear.
Mr. Nanja, I think you should put off your video so that you can hear me. Your network is fluctuating. Can you hear me now, Mr. Nanja? Okay, but I think Prof hears me and every other person.
We are hearing you loud and clear, Your Excellency.
Thank you so much, Ambassador. Thank you. Good to see you again on this platform. I'm honored to be here with you, sir.
Thank you.
So,
I appreciate you.
I'm good. You are a great man. Yes, thank you so much, sir. Thank you so much, Sir Felix, for that contribution. Can we have can I confirm if all the inductees have the induction pledge before we go into the induction proper? And I also want to thank all the participants that are here with us. We believe that this is a stepping stone. Yes, I was saying that I keep emphasizing anytime we have a meeting with mediators or ADR practitioners, that in order to hone your skills as an ADR practitioner, at least know a little bit about mediation. It is very fundamental. It's very, very important. To be effective as an arbitrator, you need to get your hands on mediation skills. And so we have been doing a very good job in Kaduna. Let me celebrate Shati for cutting across borders to ensure that all participate or all are again with this instrument of ADR. Thank you very much for all the participants that came in from the bench. In collaborating with the bench, when the bench is comfortable with ADR, we will not have problem with the lawyers, because the lawyers appear before judges. They don't appear before fellow lawyers. When a judge is conversant and understands ADR, it is the duty of the judge to direct lawyers to go back to ADR. And that is why it is very important for us to collaborate with the judges first. Forget about the short-sightedness or the little bit ignorance of lawyers in the matter of ADR. Once the judges are comfortable, once the judges understand ADR, then the lawyers will have no option than to exploit it. So don't be afraid that lawyers don't know much about it. Let the judges get this information, let the judges work with us. We know that at the end of the day, the lawyers, the judges, and then the ADR practitioners cutting across all professions will be good to go. Thank you very much. Can I confirm if all of us have the pledge, the induction pledge? Mr. Nanja?
Yes, ma'am, we do.
Okay, fine. Just a minute here. So I'm putting off my video so that we can have clarity. Here with me, we have the Settlement House ADR Training Institute, Shati 2024 induction ceremony. This is our induction pledge, oath, and affirmation. So you will insert your name and take the oath. But before then, you will do me a favor by answering these questions before we take the pledge. Do you, as ADR practitioner, promise to follow all the rules of professional ethics that pertains to ADR?
Yes, ma'am.
So you can just answer, yes, I do.
Yes, I do.
Yes, I do. Will you discharge your responsibilities and duties with professionalism, honor, integrity, neutrality, and not engage in any behavior or misconduct that will tarnish the image of ADR and Shati as an institute?
Yes, I do.
Yes, I do.
Yes, I will.
Thank you very much. So we will take this induction oath. Put your name, I. Mention your name.
My name is not showing.
As an associate
as an associate
of Settlement House ADR Training Institute, Shati.
Of Settlement
House ADR Institute, Shati.
Do humbly and voluntarily agree.
Do humbly
and voluntarily agree
to follow, respect, promote,
respect,
promote, and abide by the Institute professional ethics.
and abide by the Institute's professional ethics
and code of conduct.
Code of conduct,
which I was taught in the course of my training.
which I was taught in the course of my training.
As well as to diligently abide by the rules.
As well as to diligently
abide by the rules
and regulations of the Institute.
And regulations of the Institute.
As an alternative dispute resolution practitioner.
As an
alternative dispute resolution practitioner.
I will discharge my responsibilities and duties.
I will discharge my responsibilities and duties
with professionalism, honor, integrity, neutrality, and impartiality. And I will not engage in any behavior.
I will not engage in any behavior.
Act. Or conduct. That will tarnish the image and name of Shati.
That will tarnish the image and name of Shati.
In the event of any allegation of professional misconduct.
In the event
of any allegation of professional misconduct
against me, I willingly will and voluntarily accept the results of the investigation.
And voluntarily accept the result
of the investigation.
Discipline.
And
or decision of the governing body.
And all decision
of the governing body
of the Institute. of
the
institute as final, including the withdrawal of my license and certificate.
including the withdrawal of my license and certificate.
In all matters coming before me, in all matters, it's an addition, it's not there, just follow me. In all matters coming before me,
In all matters
coming before me, I will discharge my responsibilities.
I will discharge my responsibilities
with honesty and fairness.
with honesty and fairness.
So help me God.
So help me
God. Thank you very much. You can insert your name. Congratulations, and you're welcome to Shati as adopted members, certified ADR practitioners, not just in Nigeria, but you can practice anywhere in the world. So congratulations to all our inductees.
Thank you, ma'am.
Very much, ma'am.
Thank you, ma'am, for the honor.
Madam.
On this note, as in my capacity as the chairman of the governing council, I hereby welcome you to Settlement House ADR Training Institute, Shati, as inducted and full member with all its rights and privileges to practice ADR with professionalism and due diligence. Thank you very much.
Thank you, ma'am.
Thank you very much.
Come now, where I want to start my name. The same place will start.
Congratulations.
Thank you,
Thank
ma'am.
you.
So insert your name, scan the pledge form, and send the soft copy back to the secretariat for compilation of names. Your certificates will be given to you in due season. The CEO will get in touch with you how to pick your certificate. Thank you very much, and God bless you.
Amen. Thank you, ma'am.
Okay. Mr. Nanchan, are you here with us? Hello?
Hello.
Mr. Nanchan?
Where my one?
Yes, is Mr. Nanchan in the house?
So like this, my own go show for certificate.
Thank you, sir. He's having a network issue or something. All right, before he comes on board, can we take any question, any observation in respect to this induction? You are now full-fledged members of Shati, so go and practice peacekeeping, peacemaking, and enjoy it. You are the first beneficiary of what you have just done because you will have peace with yourself. You will first of all resolve your own internal conflicts within yourself.
Hello, please. I have a question.
All right, sir.
My name is Comrade Shati Inusam.
Yes, sir.
Saminaka.
Saminaka, yes, sir.
Yes, please, why some this settlement ADR? Why some police people they are calling us? They are saying this is not binding. Are they not aware of this? That is my question.
Police officers are okay. Let me put up my video so that I can hear you very well. You said police officers are what?
Question is that most of the policemen don't know the settlement house ADR this for the things you are behaving as a judge somewhere.
Okay. The police in Nigeria are yet to be introduced. Well, actually, the Nigerian law has not introduced what we call victim offender mediation. There is another ambit of mediation that is called victim offender mediation that is supposed to be done in the police stations, but we're doing a sensitization with the police force. We're having a collaboration with them. We're going to sensitize them and let them understand that the law itself permits mediation, even in the penal code, particularly in the north. So we will bring up the excerpts from the laws, and then we keep informing them. But be rest assured that with time, they will get to understand this concept. They have actually been practicing that. They've been practicing the mediation, but in a way that is not really codified, or rather, let me say, not in a regulated manner, because they are not trained. But once they get to understand, and we understand ourselves, and we teach them a little bit about incident-based mediation, they will accept it, and I'm sure that they will have a free flow. So the most important thing about this mediation or ADR is knowledge. You know, the Bible says that my people perish for lack of knowledge. So we've been perishing in Nigeria for lack of knowledge of this medium of settlement, which has been in existence with us anyway from time immemorial. So with collaboration, they will get to understand that, and we're working towards that. The Kaduna State Multi-Door Courthouse is already programming an event to sensitize the police force on that. So keep teaching them and keep doing your work and keep collaborating with the judges.
Okay.
Thank you very much.
Thank you for the answer.
Someone asked a question.
Yes, please.
Yeah, the question says, can there be ADR training in Delta State, please? One
Yes.
person was over there asking the question.
Can there be ADR training in Delta State? Yes,
Yes,
there can
ma'am.
be.
I asked that question because I'm from Delta State.
Okay. Okay,
And,
you can. Yes, please go
I'm
ahead.
sorry, ma. Sorry, ma.
Go ahead. Go ahead, yeah.
Because I want my people here from Delta to also enjoy this privilege. That's why I asked that question. If there can be this kind of training for those of lawyers here in Delta. I really appreciate this. I'm grateful. Thank you.
Are you a lawyer?
Yes, I am a lawyer practicing here in
Delta,
particularly in Warri City.
Are you a member of the NBA?
Yes, I am a member of the Warri branch, Nigeria Bar Association.
Okay, there can be ADR training anywhere in the world, anywhere, not just in Delta. So after this, you will get in touch with us. We will collaborate with our partners in Warri, in Delta, and other ADR institutes so that we can organize a training for you.
Very well. Thank you.
You're welcome. You're welcome. Yes.
God
Thank you
bless
so
you, ma.
much. So
Yes,
just
ma.
get
God
in
bless
touch
you, ma.
with Mr. Nanchan, and then we can organize something very meaningful for the Warri branch. Not just for lawyers. Remember that ADR is not meant for only lawyers. It is for everybody. All right. You're welcome.
Yes. All right. Thank you, ma'am.
All right.
Again.
Yes. Any other question before we close this meeting this afternoon? Do we have any question? Okay. In the absence of any other question, I'd like to give Prof some few minutes to respond to comments and wrap up everything that we have done.
Thank you. Thank you so much.
You're welcome, sir. Thank you so much.
I congratulate you. This is amazing. It's always a joy to see new mediators. And
thank you, sir. You are our inspiration.
I've given a lot of hints in my paper. You know, a wise person, you don't need to tell them everything. You tell them half. They should be able to know what you do. I've sent my paper to Shati, and then they would share it with you. But the important point I'm trying to make is that I've noticed that in the last 30 years, many people, after being trained, they'll say, oh, come and give us work as a mediator to do. You have to be creative. I mean, when I was starting the practice of mediation in Nigeria and introducing it to the country, so you can imagine that I had to find my own work. I had to do a lot of advocacy. But now, 30 years after, it's easier. There's so many mosquito court houses. There are so many people into mediation. Even if you don't want to work with them, you don't work with them. If you look at what I was saying in my paper, look at there's several opportunities you can plug into. You look at somebody like Shegun Omuyowo. In mediation, at least in terms of money making, is made more than me. And he has told you, you're standing on my shoulders. But you see, he's finishing for that. So you should be able to do better than us because you have more opportunities. He had just my book. He read it and it's become what it is. You have the books, you have mentors, you have an organization. So please make use of it and we'll go together. And once again, I congratulate all of you. And I want to say thank you again to my friends who joined. Especially, I'm very excited to see my friends from the Francophone country. Merci, je vous remercie. Thank you very much, Ma. And over to you. Okay, you're muted, Ma.
Oh, sorry, I didn't know I was muted. Sorry about that. Thank you very much, Prof. Thank you. We're always glad to have you. And it is an honor to have Prof be with us anytime we call. And I believe that one day, not just the members of Shati, not just the few of us here, I believe that one day the core promoters of ADR in Nigeria will have a banquet and will let the government know that we appreciate them for passing the new act, which has fully incorporated mediation and regulated for us. So it's a very bold step, and I believe that Prof has already said it. You don't have to wait for Shati to look for you and say, come and do this mediation. You can enter any of the multi-door court houses and be a volunteer. You can even go to the police station and just sit down and say, I just want to be a volunteer. Some minor claims, minor crimes, minor misdemeanors, you can just say, I submit myself as a volunteer. I want to give free advice. And before you know, you're already marketing your products. Prof has already said Ambassador Shegun is not a lawyer by profession as his first profession, but he's done this mediation more than the lawyers I know. He has done it far better than some that feel that they know everything about the law. And he does it with that final touch of not coming from the adversarial aspect of it. So it is open for everyone. I want to thank all of you for being part of this program. And whenever we call upon you, I believe you will definitely answer and step up. Thank you so much. On this note, we bring this meeting to a close, hoping that our next program, because we do monthly webinars or fortnightly. So please, once you see the link, join, because we discuss very enticing topics that you cannot get it. I'm bold to say that you don't get it anywhere except Shati. Thank you very much and have a wonderful day, and God bless all of you. Merci beaucoup. A little bit of my French. Merci beaucoup. Thanks for coming, and God bless you all.
Amen. Bye.
Thank and you. Happy Easter in advance.
Happy Easter. Thank you. Bye.
Thank you, sir.
Bye.
Thank you.
Bye, everybody.
Bye.
Au revoir tout le monde.
Thank you.
And then we are glad and we seriously appreciate the knowledge you shunt into our brain. And I wish you good luck and brighter future in life. Comrade Apiako from Samanaka, Freedom for Humanity International Foundation. Thank you very much, madam.
Good enough.
Oh yeah. Look, man. Ah. Àtẹ̀lẹ́fẹ́ kí ogun toilet máa flush ṣé látẹnu ẹ̀ ní ti máa jáde sílẹ̀ àbí látẹnu màdámù náà. Yàrá kan nígbà kan táwa lè mọ̀. Eléyìí ó ìṣèlú. Méjèèjì. Ẹyọ kan. Ó náà ní confidence. Tó wà lẹ́gbẹ̀ẹ́ confidence. Wọ́n tún di ọjọ́ kan wá sọ mí pé wọ́n tún fẹ́ ṣe yẹn náà. Gbogbo ẹ̀ ló yẹ kó máa fẹ́.
Okay, mosque. Abinata, bẹ́ẹ̀ challenge mọ́tò. Self kọjá o. Wọ́n lọ jẹ́ ilé o. Kí lẹ́yìn yẹn ń ṣe? Okay. Abinata. Ọ̀fẹ́ balẹ̀ yìí mẹ́. Níbo lẹ́bùtú mẹ́ta? Swear. Okay, ó dúró lẹ́nu yẹn. Ó dà o.